This is Matt Carver, and this is SAI's Legal Vortex. So this month I'm going to talk about the behavior bill, Senate File 2428. There's been a lot of discussion around this bill. And before we get into it, I will make a bit of a disclaimer. I'm an attorney, so don't hold that against me. And that disclaimer is I strongly encourage you to continue to check the DE's website. They're going to be coming out with additional FAQs at any time, could be any day now. And so check that. And if there's ever anything that you see that's from the DE that contradicts anything that I'm sharing in this podcast, please go along with what the DE is sharing. So I'm doing my best. I've had a lot of discussions with the DE about the behavior bill. I've appreciated their work with education organizations in the state about the bill, but again, they're continuing to look at it and what it means for educators in Iowa, so check out any updates from the DE after you listen to the podcast. I really appreciate that. Now, we'll go ahead and get into some of the definitions and key definitions within the bill. And the first definition I'd like to focus upon is nonviolent disruption. So what does that mean? Now, nonviolent disruption under the bill is defined as disorderly conduct, and we have a criminal statutory definition of disorderly conduct, so that's very clear. Then it has abusive or profane language. It's not so clear what's meant by that. I would encourage you not to have students removed just because they drop a cuss word here or there or something like that. But I think this is going to be something that's going to be stronger than students under their breath saying a profanity or some type of cuss word under their breath. Bullying is also included under nonviolent disruption as defined in Iowa Code 280.28. So we have a clear definition of that. And repeatedly disruptive behavior. So that's something else to consider. Now, I'll share with the repeatedly disruptive behavior. This is not, and I mentioned this during my presentation at conference, I would not see this as a student's tapping their pencil on a desk or something. And yes, that's annoying. It's something that certainly should be dealt with, but would that be the type of repeatedly disruptive behavior they're talking about? I don't believe so. In an instance like that, a student's doing something, again, it's sort of they're being a nuisance in some way. Well, the teacher can pull the student aside, talk to them. The teacher could contact the office. Perhaps someone comes down to the office. They could pull the student out in the hallway, talk to the student for a couple of minutes about that, about their behavior, try to correct that. And the student's going back in the classroom. That's not a removal. And in my opinion, that type of behavior would not be nonviolent disruption. So with this, whether we get into the definition of nonviolent disruption or as I'm about to talk about violent disruption, the other thing I'd note is there are definitions here, and this is not a matter of just each teacher deciding on their own or each educator on their own deciding what that means. So you could have instances, whether it's nonviolent disruption or violent disruption, where the teacher, perhaps reasonably, they think it meets the definition or it meets it in their own mind. They send a student to the office, the principal hears about what it is, or the principal's designee hears about what the action was. They perform some interpretation of the law. Perhaps they contact an attorney about that and determine that, no, this really does not meet the definition, and the student is sent back to the classroom, and it would not count towards a removal. So that's something else to consider. All right, now we'll move on to the violent disruptions. So a violent disruption is an injury, and then it's property damage. And while they don't clearly define property damage, I would encourage educators to use what we already have in our administrative code regarding other forms of property damage, which is serious damage to property of significant monetary value or significant non-monetary value or importance because of violence. Again, keep in mind, this is because of violence. So it's not someone that's doing some horseplay, they're playing around and they accidentally knock something over. That wouldn't fit under violent disruption. Violence has to be a part of this. Now, to the significant monetary value, you're likely looking at they're destroying a laptop, they're breaking a window, they're destroying equipment that has real value to it. What you would not consider significant or serious property damage is they go up to a pad of paper that's in the classroom and they tear off a bunch of pieces of paper off of the pad that's hanging there that's used for instruction or something. Well, that would not fit the definition. So keep that in mind as well. Now, regarding the significant non-monetary value, that's likely something like, imagine another student in the classroom has been working on a project for some time. You know, they've worked on something in art class or some other class. They're working on it. They're very proud of it. They put a great deal of time into this project. And then the student picks that up and throws it on the floor and breaks that project the other student was so proud of. It would likely be something like that. It's not just, you have younger students in elementary school, a student does a drawing and, they do a drawing for a few minutes and the other student tears it up. Again, there should be some reaction to that or some action on the educator's part to correct that behavior, but that really would not fit the definition of significant non-monetary value. And then the other piece of violent disruption as part of the definition is assault. And we have that defined in Iowa Code section 708.1. Now with assault, I will mention also that assault, it does not always have to include someone harming someone else or hitting someone else. It could be a scenario where they pick up an object of some sort. Maybe they pick up a sharp pencil, they pick up some sharp scissors, and they pick them up and they look like they're just about to stab someone. They never do stab them, but that puts the other person in fear of harm to themselves. Then that also could fit the definition of assault in Iowa and thus be a violent disruption. Next definition I'd like to cover, and unfortunately this isn't clearly defined within the statute, and we don't have a definition as of yet on the FAQs, but again, be looking for this, is severe and pervasive conduct. And so this is what I'm calling a sort of a discipline maximizer. So if the student has this severe and pervasive conduct, and it might relate to nonviolent or violent behavior, and then the classroom teacher shares that it's severe and pervasive, the administration should, again, still make some analysis of this. You're likely talking about, although again, it's not in the definition, but in the first set of FAQs from the DE, they mention multiple removals. So it's probably more likely to come into play if this is something that's been ongoing. But if that happens, and then there's a request by the teacher, then the principal shall impose the maximum amount of discipline applicable according to state or federal policy, or local. It's likely going to be under local policy, but it does reference state or federal policy as well. Then that's why I call it a discipline maximizer. So that's something else to keep in mind as you're handling these situations with student removals. All right, now I'll talk about students with disabilities. So because there are some additional things you'll need to consider regarding student disabilities. If a student has an IEP, then each student's IEP shall, again, they're using that shall or must language, be accessible to each school district employee who's responsible for the implementation of the student's IEP, including regular education teachers, special education teachers, and any other service provider. So again, you need to have accessibility of those plans so those staff members are able to review those plans of the student they're serving. Then beyond that, such individuals must, and again, must, shall, same thing, also read all changes to the accommodations or modifications described in the student's IEP, and the regular education teacher shall provide written notice to the special education teacher who's on the student's IEP team, indicating they have read the most recent changes to the accommodations or modifications. So again, there's a reference specifically to the regular education teacher that they shall provide this written notice to the SPED teacher who's servicing that particular student about the review of any changes or modifications made to the IEP. Also, teachers who instruct students with a 504 plan must also provide similar written notice they've reviewed the 504 plan. Some other considerations for students with disabilities is that if the student's removed, it's likely going to be at least a half a day towards your 10-day maximum during the year, prior to which time you'd need to do a manifestation determination meeting. So that's something to keep in mind. So it might be the last couple hours of the day, but my encouragement is that you're likely going to need to count that in at least a half a day chunk towards that 10 days of removal. And so you're going to need to keep track of that as well. Another important consideration is it is not considered a removal if a student, pursuant to their plan, is taken, they might be even taken from the classroom for some reason, but it's considered a supportive action in accordance to a student's plan. So again, all the more we want to make sure that the plans are being written well, and if you have students who are going to need those supports that might need to be pulled at times, we want to be real specific about that in the plans, because if you're able to show that you're following the plan and that's just a supportive action, then it will not be counted as a removal under the law. Now, as far as when IEP meetings need to occur, and there was a lot of discussion about this after the bill initially came out, and we have some additional information on this from the DE as far as required IEP meetings. You do not need to do an IEP meeting after every removal. You're not required to. Now, if the staff believes there's some reason why that needs to occur, of course, go ahead and do it. But as far as the bill is concerned, it's not required after every removal. However, it is required for the first removal, and this is for either nonviolent or violent. You'd need to have an IEP meeting, and it's a bit of an expanded IEP meeting. So keep that in mind as well. There are some additional staff members who need to be part of this expanded IEP meeting the first time that the student is removed from the classroom, if it's practicable. Okay, so now at times you're not going to be able to get all the staff members who are mentioned in the bill to attend the meeting, and we understand that. However, you need to make your best effort to have them participate in that meeting, and then there are some specific questions that are in addition to what they'd normally cover in an IEP meeting that have to occur for that first meeting. Now, if a staff member is unable to make it to that meeting, they will need to review the minutes or the notes from that meeting and then provide notice to the SPED teacher that they have reviewed those minutes or notes. So keep that in mind. So those staff members that can't make it, they need to review the minutes or notes from the meeting and provide notice that they've reviewed those minutes or notes. So the next time, outside of that first removal meeting, the other time where you need to have an IEP meeting under this law is if you have 5 removals within a 15 consecutive day period. And so consider this 15-day period, consider it sort of sliding on the calendar. So you have a removal, well, then it's going to be a 15-day period from then, or have there been 5 removals. Now, even if you have that, you have the 5 within 15 at that time, it's not the expanded meeting, which you need to have for that first removal. It's just more of a typical IEP meeting that would be required. Now, outside of that requirement, again, of course, you have other requirements just under state and federal laws as to when you'd need to have an IEP meeting. So you're going to want to keep that in mind as well. For practical time frame, or considering this, the DE's guidance would be to utilize the same practicality as school would use to hold a debriefing meeting in Chapter 103. So when you're trying to think of the timeline, when are you able to have this? Of course, there's going to need to be notice if you have an IEP meeting to the parents or guardians, so that they're given some reasonable period of time to be able to attend this meeting as well. But that's the recommendation as far as sort of thinking about the timeline. Another thing is the student may return before that meeting occurs. So it's not as if the student needs to stay out of the classroom until you have these IEP meetings. Next topic I'd like to discuss is the Oversight Review Committee. And so this is the committee that has 2 teachers on it. So there are 3 individuals on the Oversight Review Committee, and this is at each attendance center. And then you also have either an administrator, or you might decide that they might delegate that and instead have a counselor, mental health professional, a behavioral interventionist, or someone else who's been delegated this responsibility by the administration to attend this meeting. So it's a 3-member committee. The attendance center does either need to select the 2 teachers that are on this, or they'd need to vote to delegate for someone else to select those teachers. But the bottom line is you need to make sure that each attendance center, that the teachers in that building have the opportunity to either vote to specifically select those 2 teachers, or to vote and say, well, we'd like the central office or someone else to come up with a plan as how those 2 teachers are going to be identified. Now with this, don't think of the Oversight Review Committee. They're not like some tribunal or something, some panel of judges that are going to have to participate in each removal. Instead, their main focus is that they're going to get together, and I know some of you are already in the process of doing this right now or have already done this, and they're going to come up with recommendations relating to return of the students after removal for nonviolent. The recommendations for nonviolent, and then I'd call them guidelines for violent, because they need to be followed a little bit more strictly for the violent removals, unless you have the classroom teacher approves for an earlier removal. And we'll talk about that a little bit more in a bit. But again, this is not something where they're constantly going to have to get back together. Oh, there's removal, and these 3 individuals are going to have to get together again. No. It's more that they're coming up, and the language they use in the bill is policy. Again, I'd look at it more as guidelines or recommendations is sort of how I'd view it. But it could be a matter of they get together in an afternoon or a day, they come up with these. It is okay for them to consider the different age groups. Matter of fact, it would make good sense for them to consider that they can come up with different, what I'd call bands, even within, let's say, an elementary school. So even, let's say, for the K through 5, that committee might decide, well, we're going to treat K through 2 this way, we're going to treat grades 3 through 5 this other way. Perhaps there's a little longer removal for those students, and so on and so forth, and then moving all the way up as students progress through your school. So that's something else to keep in mind as they're coming up with their recommendations or their guidelines for return to the classroom. For nonviolent, I'll now talk about nonviolent disruption removals. As I talk about this will be for both K through 5 and 6 through 12, because they are segmented between the 2, but I'm going to talk about all of these together, and then I'll share some distinctions. So for nonviolent disruption removals, the teacher may, so they're not required to, so you could have something that meets the definition, but the teacher decides, well, this meets the definition, but I'm not going to remove the student. And the teacher has that prerogative to make that decision. But they may remove a student causing a nonviolent disruption from the classroom and have them placed under the principal or their designee supervision for at least 30 minutes at K through 5. So that's going to be the minimum time frame for K through 5 for nonviolent is 30 minutes. And then here's the distinction for grades 6 through 12. If they're removed, it fits the definition for nonviolent, they're removed, they may not return until the next day. Okay, so that's sort of a key distinction. Hopefully that's gotten out there already, but make sure that you're aware of that. For 6 through 12, nonviolent, they may not return till the next day. Now, after that removal, there will need to be some sort of meeting between the administrator and the teacher to discuss what has happened here relating to this, relating to the actions that the principal has taken, discipline of that student, and so forth. I've gotten some questions. Well, does that have to be an in-person meeting? I would say no. It doesn't necessarily have to be in person. That's ideal. It could be a video meeting. It could be a telephonic meeting. It could be, but it does, I think, under the definition of how we normally interpret a meeting, it does need to be something where there's back and forth communication. So that's what I'd recommend, is something where there is some form of back and forth communication between the administrator and the teacher relating to this meeting prior to the readmission of the student. Also consider that teachers have rights, and this is for both nonviolent and violent. The teachers do have rights to request an IEP meeting. So if they believe there's a need for an IEP meeting, they have a right to request it. They may not demand it occurs. This is something that the IEP team would just take under consideration, but they do have that right if they wish to request an IEP meeting. So that's something else to keep in mind. Now, for the nonviolent disruptions, if there's a repeated incident, and repeated is considered more than once within a semester, trimester, or quarter equivalent, okay, so that's, or it could be something in a shorter period under your own policy, that's up to you, but that's the baseline is that it needs to at least be during or multiple during a grading period. The teacher must participate in a meeting in those instances for nonviolent with the principal, a qualified guidance counselor, the parent guardian, and the student to discuss the behavior and establish a behavioral plan, course of discipline, which may include alternative placement, such as a therapeutic classroom. Also, for multiple removals at this time, and again, hopefully we'll get more information on this, but this time it's my understanding for multiple removals, there must be either ISS, so an in-school suspension, out-of-school suspension, or recommended alternative learning from the principal to the superintendent, and a determination of whether or not there needs to be an alternative learning place for that student. So there would, at the very least, need to be a ISS. Now, it doesn't say how long that ISS needs to be. So keep that in mind. You have some flexibility as to the length of that in-school suspension. You're likely going to consider the extent of the particular behavior, the age of the student, and all those things. But there's nothing in the bill that says the ISS has to be at least a half a day, or it has to be at least a day, or something along those lines. So that's something else that you'd want to make sure that you're considering. Beyond this, of course, make sure you're complying with anything that's in the student's plan. Next, I'll move on to violent disruption removals. And again, I'll cover K through 5 and 6 through 12. Now, in this, there's not flexibility. So if it meets the definition that I went over earlier, the teacher shall remove a student causing a violent disruption from the classroom and have the student placed under the principal's supervision. So that flexibility is gone for violent disruptions. And again, this is for both K through 5 and 6 through 12. The student cannot return to the teacher's classroom until the teacher and principal or designee meet to discuss the readmission. And unlike with the nonviolent, and I might not have made this clear enough, because you could have an instance for the nonviolent where the teacher doesn't agree and they return. It might even be earlier than what was in the recommendation from the committee. That's not the case with violent. With the violent, the principal cannot return the student without the teacher's consent unless they're following the Oversight Review Committee's policy regarding return. So with violent, you could have a scenario where the principal and teacher talk. Teacher might even decide or agree to return the student earlier than what's in the guidelines. That is possible. You could have that they decide, you know what, I'm fine with them coming back. It's before what's in the guidelines from the Oversight Review Committee. You could have that scenario. Or it's a scenario where the principal says, well, I'm following the guidelines. and I'm returning the student because I am following the guidelines, they would be able to do that in most instances. Now, keep in mind that like the nonviolent, with the violent as well, as you can imagine, for the grades 6 through 12, the removal may not, or the return may not be until the next day at the earliest. So that's something else that you're going to have to consider, is that for 6 through 12, again, the return is not until the next day. If the teacher's assaulted, so if you had a scenario where it's a violent removal and the teacher's assaulted, then the teacher would need to give approval so that the principal could not send the student back just because they're following the guidelines in that instance. So you're going to need to have teacher approval before that student returns to the classroom. Now, with that, going back to students with disabilities, you may have a scenario where you have to, under state and federal disability law, you'll have to explain to the teacher that, hey, to provide a free education, to provide FAPE to the student, they're going to need to return to your classroom. That would then potentially override the ability of the teacher to prevent that student from returning. So keep that in mind as well. Now, with the violent, again, the principal's going to have to determine the disciplinary action they're taking against the student. I mean, it's likely going to be a bit more significant, as you can imagine, according to your policies for violent behavior as opposed to nonviolent behavior. And the principal also want to provide written and, if possible, electronic notice of such disciplinary action to the student's parent or guardian. And so with the older students, as with many things, again, it's just like violence going to be more significant discipline. With the older students, you're also likely going to have a bit more discipline in those instances. Beyond having that meeting, the principal, or part of that meeting that the principal will have once again with the teacher, they will have to share what disciplinary action they're taking relating to that student. And then, of course, with students with disabilities, make sure you're documenting for all students, but particularly make sure you're following what's in the IEP or 504 plan, and it's being documented in those areas as well to ensure that student gets this full support they need. For subsequent removals, so for multiple removals for a student with violent removals during a grading period, the principal must impose stronger disciplines such as suspension, ISS or OSS, expulsion, or placement in an alternative learning environment, therapeutic classroom, as outlined district policy. Now, with one other distinction between the violent and nonviolent removals is with the multiple removals, you do not have to have that meeting that I discussed earlier, that larger meeting where the parent comes in, and we're not necessarily talking about students with IEPs, but you do not need that multi-party behavioral plan meeting like you need to have for nonviolent repeated removals. So that's another distinction you should all know. So with that, that's all I had to share on this month's podcast. Hopefully you find it helpful. Again, there's going to be more information coming out. I have no doubt about that. If you have any other questions, you know how to reach me at 515-267-1115 or email me at mcarver@sai-iowa.org. I appreciate what all of you do. Have a good one.